it really does make sense that a financial agreement is entered into at the earliest possible stage. But the problem that you have with that is that, again, that whole notion of no one enters into a relationship expecting to fail. So,
do it on the first date? Do you do it on the second date?
Yeah, exactly right. So it's like, how do you broach that conversation? Yeah. That's a difficult conversation that I have with clients. Not so much that my conversation is with them is difficult, as I say, it's a difficult conversation to bring up with your partner. How do you have that without them getting offended or becoming offended by that? So it's really hard to quantify in that respect. But from a legal perspective, if you can enter into one, it's going to give financial certainty.
Welcome to the Young Money Podcast with Rohan McAdam. This episode of the Young Money Podcast is brought to you by More Time Financial, a financial planning, money management and financial education business helping young Australians to make smarter decisions with their money.
Welcome to episode 30 of the Young Money Podcast. I'm your host, Rohan Marais. I'm a financial advisor, business owner, and currently living on the sunny Gold Coast in Queensland, Australia. To all of our regular listeners, welcome back to the show. And if you're new here, thanks for stopping by. The Young Money Podcast is a discussion with and about young people, including travel, lifestyle, business, relationships, and of course, money. So in my role as a financial advisor, I get to meet some pretty amazing people who all have an interesting story to share. So whether that's clients that I'm helping manage their personal finances, other business owners, or other professionals that I meet in the industry, I wanted to be able to provide a platform to share some of these amazing stories to help inspire and educate you, the listeners. Now, in today's episode, it is no different, and we're talking about the very interesting and strange topic of family law. So I'm sure I wouldn't be alone in saying that there feels like to be a lot of misinformation amongst the general public or online about what defines a de facto relationship, what happens in the event of a divorce, if you go through a separation and you own a property or have children with your partner, and basically all those things that affect us as young adults on a daily basis. What are our options? What are our rights? What does the law say? And basically what happens when a relationship goes bad. So I thought it was a great opportunity to bring in an expert to discuss all of these weird and wonderful topics. And my guest today is Rohan McAdam from McAdam Family Law. And as you'll hear throughout this episode, Rohan has a wealth of knowledge and expertise in the area of family law and helps to bust some of these myths surrounding all of those very much taboo topics, as I said, of relationships, divorce, separation, property settlements, and child custody. So strap yourself in, and I hope you enjoy the episode. Now, before we get started on today's episode, this is just a friendly reminder in order to keep our lawyers happy that in preparing this podcast, myself and any contributors have not taken into account any particular person's objectives, financial situation, or needs. So before acting on any of this information, you should consider its relevance to your personal circumstances, and if required, seek the assistance of a licensed professional.
So, Rohan McAdam, I'm 35 years of age. Wow, okay, 35. And occupation, I am a family lawyer, but I'm a director of my own practice, McAdam Family Law.
Excellent. So your resume, your career, kind of to date, what's in a snapshot?
It's relatively brief in that I studied here on the Gold Coast, finished school at Coomera High School, the northern end of the Gold Coast. Went to university, or graduated there in 2001. I then attended Bond University in 2002. I'm pretty sure I went straight into it.
Yep.
And was fortunate enough to get a half scholarship through high school. So went to Bond, which was convenient because I lived on the coast my whole life.
Yep.
Studied there full time to a point where I then got a full-time job working as a law clerk in a pretty well-established and renowned criminal law practice in Southport. Cut my studies down to part-time at that time, so that extended things out quite a bit. But finally graduated, I think, in about 2007, admitted in 2008, and then worked as a solicitor from that point in time at that practice, primarily focused in criminal law, but then moving into family law.
Okay.
before then jumping to another practice, Gold Coast based, but which was just family law, all family law practice. And worked my way up the ranks there up until June of 2018 when I decided it was time to branch out and do my own thing, and started my practice, McAdam Family Law, as of July 1st, 2018, and still doing that.
Excellent.
Yeah.
So just tad over a year.
Yeah, that's it. Just over a year. Yeah, so hit that anniversary, which was a goal. So yeah, that's good.
How's it been first year in business?
It's been good. It's been a great learning curve, but it's been different to some degree. Obviously, not having owned a business previously, but it's good. I just really enjoy being able to do the things that I intended to do when I first got into law, and being able to achieve those things. It's been really good.
So was that the main driver behind starting or branching out on your own? Just want that freedom or that flexibility?
Yeah, look, that was certainly, I'd be lying to say that it wasn't a part of that decision, but it wasn't the main part of it. It was also, as well as that, factoring in doing what I do for a living and being a family lawyer. And it means a lot to me to do what it is that I'm doing and what it is that I'm dealing in with people's lives. And recognising that. So that would have had to have been the biggest driver of doing what it is that I'm doing now, and that was to be able to not actually deal with clients as a number or as a dollar sign, but to actually give them the service that they need for some of the most important things in their lives, or their kids, or their family home, or their life savings, whatever it might be.
Definitely.
Yeah.
Excellent.
Yeah.
So what's probably the simplest definition of what is a family lawyer?
Simplest definition. So family lawyer can be a lot of things, but primarily it's a solicitor who solely practices in the area of family law, which is dealing with married or de facto couples in terms of property settlement, parenting disputes. There's a whole raft of other areas in family law, but it's primarily focused in dealing with just family law disputes.
Okay.
Yeah.
And that's wholly solely what you do, family law.
That's it. That's exactly right.
Else.
No, nothing else. As I say, I have a background in criminal law.
Yep.
That was my beginning, so I'm able to use and apply some knowledge that I've been able to gain back at that point of my career. I suppose the only thing that I would say is that I do touch into domestic violence, which is, I think, a bit of a nexus between criminal law and family law, because it does very much impact on family law situations, but it also entails criminal prosecution sometimes with breaching a domestic law. So family law, domestic violence law. Okay. Yeah.
And what, I guess, drew you to that area of law?
Yeah, initially it was more that it was an option, or perhaps something that was given to me as a path at the original practice that I worked at. Having started in criminal law, that was where I thought I wanted to be in. But having worked in that area for some time, and the clientele and what it is that we do, it was not that it was a problem, but when I was presented with the prospect of dealing in and operating and practicing in family law, I jumped at it. I just really enjoyed the notion of going back to that simple premise of helping people out at a pretty desperate time with their need for some pretty important things. And I was just able to have that insight back at that early stage to realise that was that drew me more to that area than what it was that I was doing.
Making a bit more of a difference with that?
Yeah, I think so, because I think to some degree, I think people, when they get into law, I think have this notion that they do want to make a difference in some way, shape or form. I'd like to think so. Yeah. When I do a bit of soul searching for myself, that's certainly what I thought when I really wanted, when I said to myself when I was a kid that I wouldn't mind going into law. Then when you get into it, it's a little bit different, particularly with what it was that I was doing. It became a little bit different, but then that opportunity for family law to have a think about and to go back to those basic principles made me realise that, that really allowed me to achieve that ability to make a difference in people's lives, potentially.
Yeah, excellent. Love it.
Thanks. Yeah.
So, typical day in the life of family lawyer, if there is one?
Well, I can only speak for myself in so far as what I do, but typical day now begins at about somewhere between 4:30 and 5 o'clock in the morning with my daughter, who's just turned 3 in August. So that's an early start. It's a pilgrimage down to our local cafe for a coffee and a baby chino, and it's still the case. I've been running this line for literally 12 months, and it is the truth. We do it every morning, basically, if I'm not in court. But that's how it begins, and then just getting ready, and subject to whether I'm in court or not will depend on where I'm kind of going to. But it's getting on my bike and living in the area, which is great, and getting into the office, or as I say, making my way up to court, generally in Brisbane. But it's just then dealing with clients, and
you feel like you're almost living 2 lives in the fact that obviously working at Karma, a lot more casual, and then you go into Brisbane, going into a court setting. Like, is there that disparity between?
Definitely, because when you think about a lawyer, I think more often than not, people will think, well, corporate, stuffy, suit and tie. I think this day and age, whilst that was the norm previously, I don't think that is necessarily the case anymore. Just the diversities of businesses and structures and how they operate, it's not something that's necessarily required. So for me personally, I'm extremely happy having come from that period where it's all been about corporate, suit and tie. I love the fact that I can jump on my bike and you don't
drive your Ferrari to work anymore.
No, I wish.
You just ride your bike.
No, I do literally. No, the Ferrari stays at home in the garage. No, I wish. Can't fit a baby seat into a Ferrari. But I love the bike. I love the bike. It's I love making a difference in that respect as well. Not having to have a smaller carbon footprint. I love it. I enjoy just that. I love the working where I work in the area that I work, which is a co-working space, but then that mix of then still having that corporate stuffy feel of going to court and the suit and tie. It's just that'll never change. But
we might get into this a little bit later. But what percentage of your time would be spent actually physically in a courtroom as opposed to obviously the rest of the other stuff?
It's a good question. It's really tough, particularly how family courts operate. You find yourself in court quite a lot periods of time, and then for a couple of weeks, because you happen to have matters listed all in this block of time. And other times you find that you're in the office then for playing catch up for the office work for the next couple of weeks. So it really is hard to say. Sometimes I would say 50-50. You'd find yourself when you're really add it all up, you'd nearly be 50% in the office, 50% in court. Might deviate here or there, a bit on either side, but it's half.
Okay.
Yeah.
Excellent. Well, obviously, pretty excited to have you on board for the podcast, as we talked about when we were trying to tee this up. Was obviously the things that you deal with has a direct impact on people's lives, people's bank accounts, especially their bank accounts. And obviously with the statistics around marriage, divorce, all those fun things. I thought it was a pretty interesting topic to kind of bring up and try and break some of those myths that I'm sure that you deal with on a day-to-day basis. I know I see and I suffer from some of those kind of misconceptions of, okay, well, what is a de facto relationship? What happens in a divorce, and all those fun things. So I thought it might be good to try to step through when it's typical. Obviously, it's probably not the normal, but what we would assume is the general kind of life stage of most adults, or the normal adult life. Getting a relationship, marriage, children, property.
That's it.
And then obviously divorce and those fun things like that. So
that's it.
I thought we might try and start with a de facto relationship. So most people, male or female or same-sex couples, getting into a domestic relationship. What defines a de facto relationship? Because I know from my perspective, and I assume a lot of other people, has always had that notion of, as long as you're living together for a year or 2 years, there's that point, okay, you're de facto, and now everything, if you break up, everything's halved. I think that's the stereotype.
Sure. So it's the definition of de facto is not as clear cut as what you'd like when you ask what's the definition. There's a lot of factors that get brought into play about determining, well, from a court's perspective, what is a de facto relationship. But the most important things to look at, first and foremost, is, as you mentioned, is duration. It goes without saying to some degree that it's accepted that a de facto relationship in terms of length is generally one that is ongoing for at least 2 years. that would be, whilst it's not solely required, it's something that to some degree is when determining whether a de facto relationship exists or not. So it's definitely 2 years. People sometimes think it's a year, or people just think the mere fact that you start living together. Not the case, but generally 2 years is the magic number, as it were, that's looked at. But then there's a whole raft of other things that also get brought into the equation, such as cohabitation, geography, such as your connection to the particular state in which you're residing, financial dependence, how you're perceived to friends, family, the public generally, sexual relationship, all of those things, parenting if there's children involved. All of these things get thrown into the mix, which are not exclusive. You don't have to have all of them. You don't have to have just one of them. You can have a combination of them, or you could just have a couple of it. It really just depends. So it makes it a bit difficult to be able to give that clear-cut definition. Yeah. But I think the starting point for anyone wondering whether they're in a de facto relationship is at least 2 years is a good starting point for any person. Okay. Yeah.
So that would be the start of a relationship.
Yeah.
And then if we fast forward, for whatever reason that relationship breaks up.
Yep.
Obviously, no pets, no house, no kids. There's probably a lot cleaner split.
Yep.
But once we start adding those things in, what happens in the event of, all right, we own a property together, we're in a de facto relationship.
Yep.
Is it different to that of if we're married, or is it treated the same?
It's much treated the same. It really just comes down to then the duration of the relationship. It comes to the contributions that were injected by the parties to acquire that property in that circumstance. So the Family Law Act will treat a de facto couple the same as how they would, to some degree, the same as how they would deal with a married couple in terms of a property division. If it's established that there's a de facto relationship, they'll start using the same principles that they would use for a married couple to determine, how is it that the property will be divided between them.
Okay.
Yeah.
Have you got any interesting stories of, I'm just thinking probably the interesting one would be when someone's arguing de facto and other partners saying, no, we weren't.
Yeah.
Do you come across
You do
that?
come across that. You do come across that a bit, and that can get complicated, and it can take up a lot of time too, because that in itself is a legal argument. That whole issue of, well, we weren't in a de facto relationship. It's not just as simple as showing bits and pieces. It's a really in-depth legal argument, but you do come across it quite a bit.
And do they rely on, like you said, one of the limbs being the public perception or family and friends perception? Is it a case of them coming forward and saying, we believe this, we believe that relationship, and having that argument? Like, does it go that far?
Yeah, they do. They bring in all of those things. You'll present evidence to support that you were living together for a set period of time, that you had joint bank accounts, that this is the level of dependence that you had on one another. So all of those things start coming out of the woodworks, and documents to support or evidence to support what you're saying. So it gets pretty in depth.
Rabbit hole.
Yeah, it does. It does. Yeah, and it's not that it's a shame. It's necessary sometimes, but it's that in itself, as I say, before you can even get to the substantive issue of division of property, you're dealing with this mini trial or legal battle, which in itself can be pretty time consuming.
Yeah, I bet.
Yeah.
So what tips would you give someone if they are entering into a de facto relationship? Going back to those kind of three things: getting a pet together, or buying a house. Obviously, children. We can touch on that later, but I think those would be the kind of the initial steps that we would generally see.
Yeah.
Get a relationship, get a pet, or buy a house together.
It's funny. I saw pets is something which does come up every now and then, and people get attached to pets, and understandably so.
Yeah.
Pets, though, obviously, whilst some people treat them like children, they're not children. So the laws that apply when it comes to parenting arrangements.
Apologies for all the pet owners.
That's it.
Listeners.
Yeah, exactly. It's not as if the court is going to run a proceeding based on who's going to get Fluffy or whatever they're called. Pets are treated like assets.
Okay.
And it sounds a bit silly, but if you don't treat it like an asset, well, how do you deal with it is the question that comes across, from a solicitor's perspective. You have to treat it with a value, which you wouldn't treat a child that way, and you can't, and nor should you. But a pet is difficult to quantify because it's treated a particular way, but yet in terms of the law, but in terms of how people, care for that pet, it's like a child. So it crosses that confusing threshold. So in terms of what it is that couples can do when it comes to pets, not much. I don't know. Maybe get it registered in your particular name and treat it that way. And then if you want to retain the pet, then maybe that gives you the legal ownership of if it became a bit nasty. There's not really much you can do when it comes to pets, which is the unfortunate. You have to treat it like an asset. Property, however, is a little bit different. There are things that people can do to protect their interests. First and foremost, the difficulty with it is that people never go into a relationship expecting it to fail. And so the things that you can do, people just don't do because why would anyone need that? No one intends to break up. We're going to stay together for a long, long time, and invariably it doesn't happen that way. But things that you can do is you can enter into special agreements, legal agreements, which document, in essence, what is going to happen in the event of a separation. So for a property, if it's jointly owned, then the agreement can stipulate that the property is sold and proceeds divided evenly or equally, or by any percentage that they nominate. That one party might buy the other one out, whatever the situation might be. And that's generally called a financial agreement. But that's something that people can do in anticipation of entering a de facto relationship or being in one and buying assets with one another.
And is there anything before that legally that they can do, or does it go from next to nothing besides kind of having a conversation to then the first legal step would be a binding financial agreement? In so far as an agreed step to protect everyone's position, there's, without going into property acquisition and having it in joint names and things like that, but just focusing on the family law side of things, there's not much else that really anyone can do. To do nothing means that it's up in the air. So really the only thing that you can do prior to any dispute to protect one's interests or respective interests is a financial agreement. And that's what obviously in America they call prenup.
Colloquially known as prenuptial agreement. But that's right. That's what they're more commonly known as. And they can be entered into by de facto couples, by married couples, and it can be prior to the early stages of a relationship or anticipation of entering into a relationship, marriage and cohabitation, and then after separation you can enter into an agreement here in Australia, into an agreement, a financial agreement, any of those stages.
And that's more of a settlement to say, okay, this is what's happened.
That's exactly right. So compared to obviously the beginning, this is what will happen in the event of separation, or entering into that same agreement after separation, it's more, well, we've separated, this is what we're going to agree to do to the division of our respective or joint assets.
So maybe if we dive a little bit deeper into the process around a binding financial agreement, because I know for myself and a number of clients we've spoken to that it's needed, and then it all gets too hard, maybe gets too expensive in some cases, and then it just doesn't get done. Which is the scary part. From obviously where I sit, and don't want that to end up getting to that point, but obviously put that protection in place. So what would be the steps involved? When would it be needed, or when would you see the most need for it?
Look, it's it really does make sense that a financial agreement is entered into at the earliest possible stage. But the problem that you have with that is that, again, that whole notion of no one enters into a relationship expecting to fail. So
do you do it on the first date? Do you do it on the second date?
Exactly right. So it's like, how do you broach that conversation? That's a difficult conversation that I have with clients. Not so much that my conversation is with them is difficult. It's a difficult conversation to bring up with your partner. How do you have that without them getting offended or becoming offended by that? So it's really hard to quantify in that respect. But from a legal perspective, if you can enter into one, it's going to give financial certainty. But the problems that you've got from a social science or emotional standpoint, I can't comment on those. But I appreciate and accept it would be difficult to have that conversation. It brings about mistrust. It brings about a whole raft of things, and so. But leaving all that aside, the sooner you can do it, the better.
Yeah. So I generally see it as if there's an unequal, like if you start in a relationship unequally in terms of. So maybe someone's bringing in a successful business and a large pool of assets or a large inheritance or something like that to the relationship, and you start off and it's unequal.
Yeah.
Then that's when I kind of try and bring up that conversation about, hey, it could be worth considering. Yeah. Again, not saying that you're ever going to break up.
Yeah.
I think that's generally one side that I have that conversation around. The other part being if someone's had a split and gone through a nasty breakup before, then it's like, okay, well, this is a little bit easier topic to bring up because obviously the person is naturally going to be 100%. Cautious.
Yeah, definitely. It's one of those things where the majority of clients that I have who are wanting to enter into a financial agreement, more often than not, I don't know the percentages and whether this applies across the board, but certainly from my experience, the clients that I have that want to enter financial agreements are ones who have previously separated, who have gone through the roller coaster that is, or maybe the circus that is, a family law property division. They realise that these things are important, and that whole, hindsight. Had I done this, then this could have all been avoided. More often than not, it's clients who have actually gone through it. That's an easy way of broaching the conversation. But you're right also. People who bring in more than the other party, a good reason too, but I can still imagine a difficult conversation to have. Exactly. I don't think the conversation gets any easier. Justification perhaps makes it a little bit easier to justify, but it's still a tough conversation to have. But the sooner you do it, the better.
Now, I'm sure we could probably do a 2-hour workshop on the process of getting in place a financial agreement, but is there maybe just a summary in terms of what's involved, the costs potentially, or the estimates, and the general process?
So the requirement for a financial agreement, in order for it to be a legally binding document, it's necessary for both of the parties to be legally represented. It can't be something which the parties just agree to on their own. There is a requirement pursuant to the Family Law Act that the parties both independently receive legal advice, and there are things that are required as part of that legal advice.
And is that a state-based law, or is it Australia?
Family Law Act is a federal piece of legislation, except for Western Australia, who have their own set of rules and laws over there. But outside of Western Australia, it's a federal piece of legislation for all other states. So it requires that independent legal representation for both parties. And insofar as costs, it all really varies depending on who's going to prepare it, and obviously what practice prepares the document. But invariably you find that the solicitor who's going to prepare the document will have to undertake a little bit more work than the party that's not preparing it. And so the cost will be more for perhaps that party than the other.
Do you deal much on the binding financial agreement side of things? Like, do you do a lot of those?
Yeah, look, it's yes and no, and that in itself is pretty complicated from a legal perspective. I won't bore you with that, but only because it is something that I do, is I suppose the short answer to it, but it's something that you find solicitors steer away from, funnily enough, because of the complications that come with a financial agreement being legally binding into the future. In essence, there's been recent case law that's come through that has really put a question mark on to the validity of financial agreements, and really, to cut to the nub of it, solicitors get concerned because of these agreements not being binding. They're normally known as binding financial agreements, but more often than not, solicitors have now referred to them as financial agreements because they're not binding. So that's why you'll hear me always say financial agreement, which is the same thing. But more and more you find solicitors steering away from preparing these documents because they know that they're not binding, and it leaves them liable for potential claim by their client, by someone into the future. So it depends. Some practices adopt a view, do not do them, not at all, go somewhere else. Some practices enjoy that they that other practices don't, and they invite. They take them on, knowing full well the risk. And other practices like myself, again, on a case-by-case basis, will determine, which ones we're happy to, assist with and which ones perhaps we're not.
Okay.
Yeah. But that's a long answer. And the short answer is, I do them, but it depends.
Yeah. Excellent. Yeah, because it's as you said, there's a need for it. But the process involved, it's probably easy to see why most people. Yeah,
it's a shame because it's important to have that financial certainty, but then you need solicitors to do it. But all of a sudden, you have solicitors who are saying, "Well, we don't want to do it."
Yeah.
So a bit of an interesting situation, but leaving aside the complexities that come with the law and the concern that provides the solicitors from a legal side, if parties can enter into one and it can be done properly pursuant to the law, then it is worthwhile getting one done.
Okay, excellent. So if we think about progressing down the relationship, we've gone from de facto, we decide to get married. How does that change the legal, or if it does it change the legal relationship?
Yeah, yes and no. Obviously, it changes the legal title of the status of the relationship. But again, as we spoke about before, de facto relationships are treated similarly to how married couples are under the Family Law Act. So, insofar as do they get treated differently? No, not really. Again, it all comes down to case-by-case basis. Of course, a de facto relationship, or a couple who are in a de facto relationship that that stay in a de facto relationship for 10 plus years, say, are obviously going to be treated differently to a couple who have been maybe in a relationship for a year and then married for a year. And then therefore, in total, if they're separating, have only been in a relationship for 2 years, they get treated differently. You think, well, marriage, does that not make that more important? Or well, no, it's all case by case. So again, de facto relationship, it's considered under the Family Law Act as a valid relationship. Well, if it is a valid de facto relationship, they'll apply the same principles that come for a married couple, and to some degree, that will result in a different outcome to that married couple for 2 years or for 1 year, whatever it might be. So it's all case by case.
Because that is interesting, because I guess the natural thought of, okay, that person's married, then they go up in terms of the
there's no real difference there. It does change things. It changes the legal status of one's relationship, but no, as I say, it's all case by case. It all depends on the circumstances and the situation.
Okay.
Yeah.
So obviously, binding financial agreement aside, any other tips or recommendations or suggestions for someone that is entering into a marriage?
Legal tips, not personal tips. Legal tips. Restricting it to, I don't have much experience in terms of personal tips. I'm married, or I'm happily married, so I don't have a wealth of all of these relationships to draw on anyway. So, which is a good thing. But in terms of legal tips, look, there's not much that you can do insofar as outside of a financial agreement that can really protect you insofar as assets that are acquired in the lead up or during. There's not much else that you can really do. There's getting to the putting properties into names or joint names or whatever. There's those types of things, but I think that's starting to get a little bit too kind of sinister, I suppose, in terms of it. But from a legal perspective, from a family law perspective, financial agreements are certainly things that you can do to protect people's interest in the event of separation.
So obviously, like we joked about, do you on the first date, second date, third date?
Yeah.
But it's that interesting one of, okay, at what point, and even like from a financial perspective that I see, like if you start dating someone and you're in a lot of debt, and obviously you're embarrassed by that, and that might bring strain on the relationship. At what point do you bring up that subject? And on the flip side, if you've got a lot of money, obviously people might judge you differently if they know you're quite wealthy or in a lot of debt. So at what point do you bring up that, I've got millions of dollars that I inherited. And as well, I've got $1 million of debt.
Like,
It's always that interesting one of, and it's a similar kind of thing of, okay, well, when are we at what point in the relationship do we bring it up that it's not that? Well, why are you talking about this? That you planning on breaking up with me, or do you think this relationship's going to end?
That's it. Yeah, I think that though the thing is I think that just then spills over into the personal side, doesn't it? It's whether you have the conversation or not is more of a personal decision than it is anything else. But from the perspective of I have all this money, well, again, as you said before, it makes sense to acknowledge that and to protect that.
Yeah.
And it's not with the view of hoping or thinking that the relationship's going to fail. It's just being safe and being cautious, particularly if the other party hasn't brought anything into the equation. There's that inequality, as it were.
Yeah.
The debt side of things, well, that's an interesting and a curly question, I suppose. To bring that up and but insofar as the legal perspective, not much you can else really do other than what we've discussed. So
tiptoe around it.
Yeah, that's it basically. Yeah, choose the right time.
Yeah.
Yeah. So when that is, everyone's going to be different.
Yeah, definitely. So progressing on, married. Generally, obviously, this may not be in order for given today's age. Things in the order of steps are different, but we go to starting a family, having children.
Yep.
Now that obviously is a big step up from getting the pet together.
Yeah, it is. It is.
So what are the things to consider when children are involved in a relationship?
Look, it's from a family law perspective. Again, there's dealing from a financial perspective. There's things that you can do, and from a family law, those things are limited. And obviously, from what it is that you do, there are a lot of things.
Sure.
From a family law perspective, family law is, particularly when it comes to parenting, is more reactive than it is being proactive.
Okay.
There's nothing you can do. You can't enter into an agreement like you can with property as to how the kids are going to be cared for in the event of separation.
Yeah.
You can't do that.
Sure.
It's not something that the law provides for. So, in terms of from a family law perspective, what can you do? Not much.
Not much.
Not much. It's all about what does the law provide for when there is separation. There's dispute associated with the ongoing care of children. So, not much.
So if we dig into that a little bit deeper, what happens in the event of a breakup? So we've got a married couple, or de facto couple in that case.
Yep.
If there's children involved,
Yep.
one or multiple.
Yep.
What's the proceedings if in the event of a split?
Yep.
How does that arise at
Yeah. So again, it's all case by case basis, but the law hopes and requires at first instance that parties will at least have an attempt to try and resolve, just focusing on parenting.
Yeah.
They'll have an ability to try and negotiate and come to an agreement in relation to the ongoing care of kids without court intervention.
Yeah.
So first and foremost, that's what courts want. If that can't be done privately between the parties, then again, as part of that process, the law does want parties to attend upon a special process called family dispute resolution.
And just before they get to that step, what's needed to prove that if they reach an agreement between themselves privately, what's needed to prove that? Is it a
So parties can enter into an agreement in a couple of ways. It can just be, a verbal goodwill agreement.
Yep.
That's possible to do, and people do that. It's not something that's necessarily advised because it requires a lot of cooperation between parents, and there's only a small percentage, unfortunately, in the reality of things that have that amicable relationship with one another. But that is an option.
Sure.
Goodwill. Then there's the ability for parties to enter into what's known as a parenting plan, and that then is a document which is it's an agreement converted into a written document, and preferably signed and dated by the parties.
Yep.
Which again stipulates in writing what it is that the parenting arrangements will be for the kids. That in itself, though, is not a legally binding document. It's not an enforceable document.
Okay.
And again, something which is, not that it's not recommended, it's required that solicitors are required to advise clients and parents and people going through parenting disputes to be aware of a parenting plan. But because of its unenforceability to some degree, and because of, again, the concerns that come with non-compliance, it is an option, but not one that's generally taken up as often as what the law would like people to do for those reasons. But that's another option. And then finally, there's what's known as a consent order. And that is, again, converting the agreement into a written document. But that then gets submitted to a court, to the family court. It's reviewed, it's considered. If it's considered in the best interest of children, the court will make it. And then that then becomes a legally binding and enforceable document.
Okay. So does the court and the law kind of only get involved in the event of a dispute? So if there's a split, is it only if one parent raises a dispute to say, I'm not happy with this outcome? That's only when so if there's no dispute raised by either party, then it's just mutual agreement. All right, we agree that you're going to look after the kids these days and these days, and then there's nothing wrong with that.
Yeah.
It's only when the husband, wife, or same-sex couple, someone who raises an issue, and then that's when it gets escalated up the chain. Yeah,
that's right. So in its simplest, if there's just no agreement in relation to the care arrangements associated with children, and there's no ability for that to be achieved by the parties independently or with the assistance of mediators or with the assistance of solicitors, well, in that circumstance, sometimes court intervention is required.
Okay.
There are other circumstances upon which you can find yourself into a court with regards to parenting that's not just simply off the back of a dispute between parents about the care arrangements. It could be that there is a care arrangement in place, but something's happened significantly which they need some urgent intervention. So, for instance, if there was threats being made by a parent to relocate, in a state or overseas, and that wasn't consented to, then that's a reason why you might find yourself in court to try and avoid that from happening. But to the point of what you were raising, it's generally when there's just no ability for the parties to reach an agreement themselves, and they need the court intervention.
Okay. And then, is there a set process that once those kind of boxes are ticked to say, okay, there's a plan, there's lawyer, and there's a process that you go through to reach an outcome? Yeah,
there is. So there's that. I try and break into two. There's the pre-court process, and then there's the court process. But the pre-court process, as we alluded to before, does require the parties to try and negotiate themselves. If they can't do it themselves, then to involve a process called family dispute resolution, which is in essence a mediation with an independent party to try and help facilitate an agreement between the parties. But failing an agreement in that context, you then are able to ask the court to intervene. And that in itself then has its own processes associated with that, which in its really simplest form, it's the court and a judge being allocated the matter and ascertaining the circumstances of that particular matter. But it does also involve a third party, a family consultant, to come in, interview parties, assess the situation, and to provide recommendations associated with parenting of children. So in its simplest, there is a process. It's a detailed process, but that's the main step associated with the court process.
Yeah. So not a fun process for anyone, really.
Look, it's not. It's never a fun process because invariably, as you said before, if you're in court, it's because there is a dispute. And with family law, it's high emotion. It's all emotion. And the problem that you have with emotion and thinking emotionally is it's more often than not it's irrational thinking as well. And so all of that is a perfect storm or a combination to it not being a fun experience. And then when you throw solicitors into the mix who perhaps like to buy into the emotion, then it's a recipe for disaster. And it does, unfortunately, then have that bad label of it not being a very fun process. But even all that aside, it's not a fun process at all, even if it's to some degree amicable, or it's not as bad as what you often hear. But it's a necessary process. The process, I believe, is a good process to achieve an outcome, but there are some significant problems with the system at the moment, which is what's brought about recent recommendations from the top, about reviewing the family law system. But in itself, the process that is there is a good process. It's just trying to make it more accessible to the public and trying to get rid of the backlog, amongst other things.
Okay. So again, in the event of the separation, what happens with the children, and then what happens with the finances? How does that get treated separately? Is it different?
Yeah, they are treated differently. They're two different areas of the Family Law Act, but then they do also intertwine with one another because they are inextricably linked. For instance, how a property pool might be divided is going to take into account the care arrangements associated with children, how much time a child or children is spending with one parent over the other will dictate how much property is divided in that party's favour. So it does intertwine, but the long and the short of it is that they are dealt with separately, but there are times where they intertwine with one another.
Okay.
Yeah.
So I guess we maybe skimmed over that a little bit quickly in terms of the financial pool.
Yeah.
So talk to me about what happens in that case. So again, there's a dispute raised in the event of the divorce. They can't come to an agreement themselves.
Yep.
They come and seek your services, or one party does, I assume.
Yeah.
Is it a matter of, okay, let's put everything in, find out exactly what's involved, properties, super, bank accounts, let's put everything in, and then we're going to come to some sort of agreement of who gets how much and what.
Yeah, in its simplest form to some degree. Yeah, there is a process that isn't a legislative process, but it is one that has been established as being the way upon which the law and practitioners should determine how it is that property pools are divided, speaking about property.
Yeah.
But in essence, it's a 5-step process. The first step is for the law to figure out, well, is it just and equitable for us to intervene and to split parties' property interests? That's a bit of a legal question, and I won't bog you down with regards to all of that. But it really is, if you have a relationship that is a long-term relationship, children, then the law will say in that circumstance more often than not, there's a reason for us to invoke our power to separate property of parties. Yep. Because of the fact that there's a long-term relationship, there's a lot of contributions made by them. It makes sense to do that. Whereas that might not necessarily apply to a couple who, have been in a relationship for, a couple of weeks. The law might say, well, I'm not going to involve ourselves because it's not necessary for us to do so. It's a really simple explanation to that. But that is the first step. But once that has gotten past, it's more the following steps which figure out the process of determining how it is that pools are divided. But first and foremost, as you say, it's figuring out what is the pool, what is it that the parties need to have divided between them. So that's all your assets, your liabilities, superannuation, any financial resources. Figure out what that is. That's first and foremost.
Have you come across many cases where they try and hide what they...
Oh, always.
Always?
Always, yeah. If it's not hiding, although, there's disclosure requirements, so you have to disclose everything. Yeah. So if it's not hiding, it's diminishing. It's about, okay, well, this is the pool, but we're just going to diminish the pool. If it's the bank account, all right, well, we're going to slowly have funds leave that account and go somewhere, so you do have a lot of that.
And does it, I kind of think of like a point system, like, all right, if you didn't disclose this and we found out that's like a negative, does it work on that kind of system?
No.
Like, all right, or do they just say, okay, I'm sorry, here's that superannuation account? Like,
it just depends. It depends on the, what it is that you're referring to. It'd be a little bit of a tough explanation to provide if you say, I'm sorry, I neglected to tell you about that property that I had, in far north Queensland, or whatever it might be. Yeah. Those things are a little bit, they come with a bit of criticism if you're trying to hide those things. But obviously for smaller things, again, the law requires full disclosure, absolutely everything. But there are different levels, of course, associated with different bits and assets. But you do get it quite a lot,
And how much of it is up to the parties to decide themselves? Like, if it gets to that case where there's lawyers involved and we're at that point, is it a matter of me saying, okay, I want this, but I'll give you that? Like, sure. Is it that kind of negotiation?
Yeah, look, it's that's the thing too that a lot of people don't realise is that I suppose they believe when it comes to a family law property settlement that you have to figure everything out and you have to sell it all. You have to liquidate everything and you have to split it that way. No, it doesn't have to happen that way. It can happen that way if you wanted to. But, the control and the negotiation as to how things are divided, it doesn't really matter as to how it is divided, just that it's divided in a way that is per agreement between the parties, but also is fair according to the law based on the circumstances of the party. So, as I say, if you had a property that was the only asset and it was agreed that it was a division of 50% to keep it really simple. Yep. You can sell it and then split the proceeds after mortgages and other things have been paid. Yep. You can do it that way. Or alternatively, if one party says, I want to keep it, I want to refinance it, well, as long as if the other party's happy with that, as long as they then get what constitutes what would be 50% of its value, they can pay him out that way and then refinance and transfer the property into that person's sole name. So there's a lot of ways in which you can do it. It's not just your sell it, liquidate everything, split the money, and then walk your separate ways. Sure. Yeah.
And I guess in that scenario, that probably leads into what we were talking about previously around the financial agreement.
Yeah.
And I've had some cases where there wasn't an agreement of how the property was going to get valued.
Okay.
So the one person came through and said, okay, I'm going to get this valuer.
Yep.
Whether they paid them extra to value more or less,
sure.
depending. I think that was the contentious issue, because the person who wanted to refinance, who wanted to purchase the whole property, the partner came in and said, it's valued at this much, which was way over.
Sure.
But there wasn't that agreement of, okay, you're going to get a valuer, I'm going to get a valuer, we'll get an independent valuer.
Yeah.
That was obviously...
and that I think goes back to that point of why sometimes solicitors are reluctant to dive into it, because you really have to, depending on what type of agreement you're preparing, if it is that one where it's in anticipation of separation, you've really got to think about as much as humanly possible, and that's sometimes a very difficult thing to do. But you've got to think about, well, okay, how's the property going to be valued? If the parties don't separate, if they stay in a de facto relationship for 5 years and there's a property, well, the property value now is going to be much different in 5 years' time, whether good or bad or otherwise. So, you've got to think about all of those things to avoid that conflict, and that's why you do get that. That's just potentially one reason why solicitors kind of steer clear of it to avoid that liability.
So then they come to an agreement. It's agreed that partner one's going to get so and so, partner two is going to get the balance. Then, as you said earlier, there's a settlement agreement that says we're comfortable, we're done, we cannot, is that kind of puts it in concrete to say, okay, we can no longer come back in 2 years' time. I change my mind and realise that property is now worth a lot more than I originally thought, or the prices are going up.
That's it, exactly, yeah. So if you reach an agreement, regardless of how you get there, in relation to property settlement, then 2 ways in which you can document that agreement in a legal way. You can either enter into a financial agreement. So as I said at the beginning, we talked about when you can prepare them. You can do them prior to, during a relationship, or after separation. So that's one way. The other way is a consent order. The differences between they're both the same thing in that they're documenting the agreement reached, but the biggest difference is that the financial agreement, I explain it like a bit of a contract. It's signed off on by the parties and their legal representatives, and that's it. As soon as it's signed and all the boxes are being ticked about the requirements of it being complied with pursuant to the law, that's it. That's all that needs to happen. Whereas a consent order, same thing. You document the agreement, but it's not signed off on by the solicitors, and that's it. It is signed off on by the parties, but it's sent to the court. And then the court consider it, and they consider it according to the law. And they then say, okay, is it a fair outcome? Is it a just and equitable one? Okay, great. We're happy with that. We'll stamp it and approve it and send the orders back to the parties. And then you have that situation where in both those circumstances that, yes, in a year's time, 2 years' time, again, there's circumstances where it can change, but they're there to provide that finality, so that in 1-2 years' time, there's not going to be that knock on the door saying, I want another bite of the cherry, as it were. So, that's the way in which you avoid that from happening.
Okay, excellent. Very interesting.
Yeah, there's so many things that come with that. It's not just it'd be great if it was a clear cut as that. There are circumstances which you could still enter into those documents and they can be set aside, but again, that's a rabbit hole which we won't go down. But in its simplest form, those documents are supposed to give parties, depending on the financial agreement side, but the consent order, they're there to give parties finality to move on confidently that there's not going to be additional claims made now into the future.
Okay.
Yeah.
So we obviously, you would have seen on Instagram, put questions up to see what the audience or listeners wanted to know around family law, and there's probably thousands of questions that probably didn't get asked due to privacy and issues in relationships and things like that. But we touched on one already around pets, what happens around pets, which is a fun one. The second one was what's required to make a divorce legal? Like, is there a requirement to say we are legally divorced? Yep,
so it's there's not necessarily a requirement as such, although it's advised that if parties are married and they separate, that they should go through the process of formally divorcing. I suppose one thing to clarify is that people confuse, property settlement and this notion of divorce. They tend to think it's one and the same.
Sure.
But divorce, from a lawyer's perspective, a family lawyer's perspective, it's the legal status of one's relationship. If you are married, that's, and then you want to end that, then you get divorced, and that annuls the legal status of that relationship.
Yeah.
So it's advisable that people do, although there are people who separate and they are married and they just don't do anything about it. They say, well, why do I need to get divorced? There's a lot of things that apply with, state succession law that is, advisable, which you'll be aware of, about doing, getting that legal status, determined and nullified. But in terms of getting a divorce as to the legal status, you've got there is a requirement associated with doing that. You've got to be separated for at least 12 months before you can lodge that application. And then once that has been done, subject to there not being any other issues raised by the parties, it's just an application process where you lodge it with the court, and the court will determine it on a case-by-case basis. But the first requirement is that the parties have separated for at least 12 months.
And obviously there's that both parties have to agree and sign off on them being divorced, or is there a case where...
Not necessarily. So, you can, as an individual, you can lodge an application jointly. So both parties can agree and say, yep, we've separated, we've divorced, and we want to get divorced. One of us wants to remarry, say, and so you can both jointly lodge an application. But there are circumstances where parties can, without knowing what the party wants to do, you could lodge an application as a sole application and, commence the ball rolling yourself without, as I say, knowing what the other party wants to do, whether they agree or not, or whether they're just non-compliant, they just buried their head in the sand and couldn't care less because they don't want any dealings with the person. One party can institute and run through a divorce proceeding without necessarily the consent of the other.
Interesting.
Yeah.
So I guess the way I kind of think of it is, you see in the movies, obviously they send the divorce papers to the other partner, and so we haven't signed them yet, so we can't get divorced.
Sure, yeah, that's right. Yeah, you do see that.
About that. It's obviously Americanised.
Americanised, exactly. And so I don't know how it goes over there, but no, in Australia, look, it's the same thing. You could prepare an application, and they've got to be served on the other party. As long as the party acknowledges, or there's proof that person was given the application, and they're notified about it, and they're aware of it, and given the opportunity within the appropriate timeframes to dispute it if they want.
Yeah.
It doesn't matter if they don't sign it. It'll still steam toward that hearing date, unless it is they step in and say we don't want the divorce.
Cancel it.
Yeah,
just a bluff.
Yeah, well, there's a reason why we don't want it, and I don't know why there would be. Well, there are a lot of reasons why, but you don't see it all that often. But one is someone disputing that they've actually separated for 12 months. It's a technical argument, but it doesn't really matter. At the end of the day, it doesn't matter if they don't sign off on it as such. It'll still proceed unless there's a legal reason why it shouldn't.
Interesting. So the final one we had, which is probably a bit of a contentious question, I guess, is, again, probably being Americanised in the movies and everything, that in the event of a divorce, it appears that the females seem to get, I guess that's the general notion of, okay, well, I got divorced, my wife took me for 50%. It's obviously here, and obviously the gold digger term and everything gets thrown around.
Yeah.
Is that the case, or is that a myth in terms of...
Oh, look, it's the law does not provide for that to be the outcome.
Okay.
So it is a myth in that respect, but again, it's all case by case basis as to how it is that a pool will be divided between parties. The law applies the same principles for couple A as they do the couple B, C and D, but again, the ultimate outcome is just, again, based on each of those respective couples' circumstances of their relationship, the duration, the kids, if there are any, the contributions that they've made. So, where you might, as just a really big general, where you might find a 50% division of property is in, and although this is not always the case, but where you have a long-term relationship, 10, 15, 20 years or longer, it is the more likely. But, where there's children, that general situation that you find a long-term relationship, children, contributing to the welfare of the parties, both financially and as a homemaker and caring for the kids. Where you have that type of relationship come to an end, you'll find more often than not in that circumstance there is more likely to be a division in or around that area. Again, it's all case by case. But as compared to a male or female who come in with a significant income, short-term relationship, so they get married, but it's very short-term, maybe 2-3 years, whatever it might be. Yeah. Zero contributions from the other party. The other party's brought everything in. The other one's just enjoyed the benefit of the lifestyle, whatever it might be. In that circumstance, again, it's not clear. It's all case by case, but generalised. It's not going to be a situation where more often than not that would be a 50-50 split. Yeah. It's just not going to happen. The law has provisions and steps to apply to figure out the answer to it. But yeah, the notion that just simply because you're married that all of a sudden it's going to be split 50-50, no, that's not. It's a bit of a myth.
Okay.
But unfortunately, you hear it, you see it, and you have conversations with people, and I think stories get a little bit kind of, changed over time.
Definitely.
But at the end of the day, the law does not say it's just straight 50-50, particularly here in Australia. It doesn't. Okay. Yeah.
Myth busted.
That's it. That's it. Depends on who you speak with, though.
Yeah, sure. As I said, very contentious.
Yeah.
Very contentious question, and obviously, given now same-sex marriage and all those things, just makes it again probably even more.
To some degree, again, same sex. Again, there's no different laws or different rules for couples, whether it's heterosexual or same sex, whatever it might be. It's all they're all the same. Yeah. But yeah, again, it's all just about the circumstances and then the stories you hear. So yeah.
Excellent. All right, well, we've got a couple of final questions that we try and get through all our guests. Sure. Feel free to pass it at any time. But given the fact you've been a lawyer for a long period of time, business owner for the last 12 months, how has your beliefs or behaviours changed around money as you've got older?
I think in terms of my personal beliefs, everything that I've been taught is, I suppose, to some degree true. The whole notion of saving, and obviously when you're a kid, you don't want to save, you just want to spend. And so I think throwing a family to the mix and understanding the importance of being able to support family and keep roofs over the head and food on the table, it makes sense, not necessarily be frugal, but not to be, carefree, as it were. Yeah. So, I think that's more of an understanding that, what you're told insofar as making sure that you're careful with your money is, it's extremely important. Yeah.
And that decision, obviously, to go become self-employed, obviously it's a big decision to make. Yep. Probably a lot easier for people to make when there's no kids or family involved.
100%. Yeah.
I assume that wasn't something you made lightly to say, I'm going to quit my corporate job.
Yeah, that's it. Exactly. From where I was and the practice that I was based, it was a very good practice. It was well known, and in terms of my position there, I'd worked my way up to a point where, financially it was pretty comfortable. It was not an easy decision to make, but in the same breath it was, because of what it is that I wanted to achieve and what I believed that I was able to do. But you are right, those pressures of having a family do make that decision a lot harder, because it's not just thinking about yourself. You tend to be able to, easily survive if you're looking after yourself. It becomes a little bit different when you've got a sense of responsibility when you're dealing and helping out other people. It was hard in that regard, but it wasn't hard in the same for other reasons.
Excellent. Best money advice you've ever received?
Best money advice I've ever received is from my father, and that is, it's not what you earn, it's what you save.
Excellent.
I remember hearing that as a kid and kind of understanding it and kind of realising it pretty early in my life, which I'm pretty happy about. But more so now, it's really not about how much it is. So did I say earn? Or maybe spend? What did I say?
How much you earn, how much you save.
Yeah. So sorry, that's right. Just for some reason, I thought I had a bit of a brain snap. But yeah, the saying is, it's not what you earn, it's what you save. So yeah, it's so important, you know, and just in its simplest form, you know, you don't have to have a a big office, as it were, and spend all of this money on the cost associated with fitting it out and associated with the overheads. You know, if you can work in a much more cheaper way, that's the best way of being able to live by that saying. About it's not necessarily about you might earn a lot, but if you're spending it, it doesn't make any difference. It's about where you can keep savings, and it's not about that whole typical money in bank and saving it that way. It's just about where you can save on your expenses.
Sure.
You know, it applies across the board.
Excellent.
Yeah,
love it. So, going on from that, any money-saving tips or hacks that you can recommend?
Money tips or hacks, and saying without having to say the same advice, and which would be the starting point. It's not what you earn; it's what you save.
Yeah.
But money tips or hacks. Oh, I'm sorry, I don't know if
ride your bike to work.
Ride your bike to work. Yeah, work on the basis of trying to lower your carbon footprint, and if you can do that, not only are you doing the right thing by the world, but I think you're also saving a lot of money.
Yeah.
So yeah, thanks, mate. I'll take that one. I'll use that one. Ride your bike. Yeah.
Excellent.
Yeah, exactly.
You wake up tomorrow, you won $1 million. What's the first thing you do? And the first thing you buy?
That's a good question. First thing I'd do, I'd tell my wife.
It's a good start.
Yeah, it's a good start.
You're not going to hide that one.
Not going to hide that one, yeah, for the pending property settlement. So I'd tell her, and then first thing you'd buy, geez, what would you buy? You'd go crazy, wouldn't you? Oh my God, what would you do? You put me on the spot. Go on a holiday maybe.
Yeah.
Let's just do that. That's what we'd do. Spend it on the family.
Any major destinations that come to mind?
I haven't done Europe yet, so that would have to be it. Yeah, I'd say Europe. Everywhere in Europe. Italy.
Nice.
Yeah.
Excellent. Well, thanks very much for being on board.
No problem.
Where's the best place people can find out more about you and your services?
Look online. Just on my website, McAdamFamilyLaw.com.au. That's the best place. And details are all on there, so that would be your best starting point.
Excellent. Yeah. Any final tips or suggestions?
Final tips, suggestions. Oh, geez. No. Sorry to be boring. I don't know. No, be good. That's it. Be a good person. You'll be fine.
Excellent.
That's it.
All right. Well, thanks, mate. Thanks for being on board.
No problem at all. Appreciate it.
Thanks for checking out another episode of the Young Money Podcast. If you have any feedback or any questions about this episode, please let me know by messaging me on Instagram, as well as any suggestions for future guests for this podcast. Let me know who you'd like me to interview and the topics that you would like me to cover. All the links to Rohan's website and socials will be found in the show notes below, and you can check out the full show notes at rossmarais.com/podcast. Hope you have a great day.
If you've enjoyed this episode of the Young Money Podcast, make sure you subscribe to keep up to date with all the latest episodes. And feel free to leave a like, comment, and share it with a friend.